I'm Drew Stevenson, and this is part of my introduction to administrative law and the regulatory state. Here, I want to give a quick history lesson, just the basics that you need to know in order to understand these cases. And for my students, this is actually one of the cases in law school where you should pay attention to the dates on your case, because we've gone through different phases or eras of administrative law where the agencies have been doing very different things and the courts have been responding in very different ways. And so if you see a case from the 1940s, you should read it differently than a case from the 1970s or a case from the late 1990s. So let's look, this won't take very long. I know that a lot of people find history really boring. So here's my kind of big overview of the eras of administrative law. Before the New Deal, we really didn't have much. We have isolated cases here and there. I have an antique legal treatise from the 1920s. So we have a few cases, but really this area of law came into its own or was birthed in the New Deal era. So we're talking about FDR, Franklin Delano Roosevelt's New Deal, and the massive overhaul of our federal system, the ascendancy of the federal government, and so forth. And this was, remember, this was very popular. He won re-election again and again before we had term limits for the president. The country was going through a grueling depression. People were living in poverty, and they wanted the government to do something. They wanted the government to intervene and change the situation and fix the problems. And so this was, even though historically there's this wouldn't be, some of these measures would not be as popular perhaps today, but at the time, this was what the people wanted, this was what they voted for, and they gave FDR and Congress basically a voter mandate. And so what happened during the New Deal period is there was this explosion of the federal bureaucracy and new agencies being created, and nascent agencies or embryonic agencies that have been created in the early 1900s started to take on new tasks and become much more proactive and promulgate more regulations and bring enforcement actions and so forth. And this was all part of a larger framework or fundamental change in our legal system. I really can't exaggerate how much our legal system, the American legal system, changed in the New Deal era, right? So the role of the federal government and the mentality about what the government could do and how it was going to do it completely changed and permanently changed. So this period kind of goes from the mid 1930s to 1949. And the big takeaway from this is we had lots and lots and lots of new agencies. We only had a few before this, and now they were multiplying faster than people could keep track of. And then we had some judicial backlash because this was such a shock to the system. Part of the backlash culminated in a legislative response, the Administrative Procedure Act, in the late 1940s. And so that also, the Administrative Procedure Act set a lot of restrictions on agencies, and in particular, a lot of steps they had to go through in order to do the things that they wanted to do. So that's the New Deal era, and you should think of this as a period of very aggressive agency creation and visionary progressives running the agencies or founding these agencies, some pushback from the judiciary, and eventually a little bit of pushback from the legislature. Another thing to keep in mind is that the architects of the administrative state in the New Deal era really liked the common law system. They liked the Anglo-American idea of having precedent that were evolved incrementally in incremental steps over time. So each case builds on the body of prior cases, and then the next case builds on that case and so forth. And they brought this mentality into the early days of the agencies. And so what we see in some of the cases from this period are agencies that were trying to function almost like specialized common law courts, right? So instead of having generalist judges, common law judges who dealt with everything from property to torts to pollution issues to criminal law and so forth, here we would have an agency whose whole job was to regulate the employment relationship and labor unions, like the National Labor Relations Board, or to regulate radio broadcasts and radio stations and broadcast frequencies. And what these agencies in the early days, a number of them decided to just start announcing policies and then bringing enforcement actions and sort of creating a body of agency precedent or regulatory precedent on a case-by-case basis, common law style. Our next big phase is what the 1950s to the 1970s, right? The mid 1900s. And this is a period that you could almost call hyper-regulation. So the agencies were established. They were now coming into their second or third generation of leadership. And something that characterizes this period is that the agencies really shifted a little bit more towards legislative type rulemaking instead of a common law type of rulemaking of incremental evolving precedent. So they started promulgating a lot more regulations that look like statutes, right? And that end up codified in the code of federal regulations. The agencies, again, were very active during this period, and there wasn't a lot of coordination between the agencies. So another characteristic of this period from the 1950s to the 1970s is that we had a lot of examples of duplicative regulations and contradictory regulations from different agencies. There was no centralized clearinghouse in the federal government forcing agencies during this period to coordinate with each other. So for a regulated industry or business, you would have a situation where you had to file the very similar paperwork with multiple agencies or document certain things for multiple agencies because so many of the regulations were duplicative. Sometimes you had to redo steps, first for one agency and then for another agency. And also, we had situations where complying with one agency's rules and regulations might actually put you in violation of another agency's requirements. And this created a problem. Also, there was no one really sitting on top of the agencies thinking about the aggregate compliance costs or cost of regulation on American industry. And by the 1960s and 70s, American industry is feeling that. And so a lot of our manufacturing started to move overseas and build their factories in other countries where they didn't have to comply with as many safety regulations or employment regulations and so forth. And there was a lot of political pressure, backlash against the sort of hyper regulation environment that was going on, where agencies were it seemed to the businesses were promulgating regulations as fast as they could and not coordinating or talking to each other to make sure that they weren't redundant. The big change or pendulum swing the other way comes in 1980 when Ronald Reagan wins the White House. And Reagan had campaigned on a platform of deregulation. In fact, he had a little joke that he would tell at his campaign stops. He would say, what are the most frightening words in the English language? And there was actually a popular song at the time that the scariest words in the English language are I love you or something like that. So he would say, what are the most frightening words in the English language? And the audience is thinking of this song, this pop song. And he would say, we're from the government and we're here to help. And it really captured, the people thought it was hilarious, and it captured the mood of the time, which is that people felt burdened by how much regulation there was. It seemed like it was too much. In fact, it wasn't just too much to comply with, it seemed like too much to keep track of. And so Reagan came into office with a mandate. He won in a landslide and had a mandate to deregulate, and he did. And really, the Reagan sort of revolution domestically brought about the biggest change in our domestic legal system, I believe, since the New Deal. Where just like the New Deal brought in progressivism and a massive expansion of government regulation and of the federal government, Reagan sort of really changed the landscape, and it really hasn't gone back. That's why I say until the present. And so even Barack Obama campaigned on a more progressive platform, and a lot of observers thought that when he was in office, he would kind of put it all back to the pre-Reagan era, but that's not really what happened. And so in the grand trajectory of history, we are still really in the deregulation phase, right, of sort of undoing not so much the New Deal, but this period from the 1950s to the 1970s. And now, as you would expect, there was a judicial pushback from against the executive branch and Congress in each of these periods. So during the New Deal period, the courts were like, what do you think you're doing? You're adjudicating cases, that's our job. And in the 1950s to 1970s, there were a lot of times when the courts were facilitating what the agencies were doing, but they also started to create some guidelines that they wanted more to hold the agencies to having more process and creating a better record of how they were making their decisions. And then again, we're going to read some cases where the courts are very skeptical about the sort of knee-jerk deregulation that started in the 1980s, and want the agencies to show why they're doing this and that this is good policy and that they're fitting within their statutory mandate. So again, this may be one of your only courses in law school where you really need to make a mental note of the date of the case so that you can situate it in the context of what is going on, what era of administrative law are we in. Now, I've probably put you all to sleep at this point, but that concludes our lecture about the historical phases or eras of administrative law.